On the 24th of March 2022, police in Johannesburg arrested a man called Nhlanhla Dlamini, popularly known as Nhlanhla Lux, who happens to be the leader of a self-styled movement that calls itself Operation Dudula movement. Now, he was kept in custody from the 24th right through the weekend and is expected to appear in court on Monday. And whilst the man remains in custody, a lot of people are throwing ideas around, asking questions, trying to understand exactly whether there are any grounds for the arrest of that man, whether the arrest is lawful, whether it's legitimate. Some suggesting that it is maybe the state's way of trying to prevent him from growing his movement. He was expected to address one such Dudula movement over the weekend somewhere in Durban. Now, as people continue to discuss, I felt that it would be necessary for us to discuss not just from a layman's point of view, but try to understand whether there is any legal basis for his arrest, and if so, what that could be. Thank you very much for being part of this presentation. I look forward to sharing more time with you. Yes, we have some people trying to understand the arrest from the point of view that maybe the police arrested him for taking part in demonstrations, and we have a lot of people asking themselves whether it is an offense, a criminal offense for anyone to take part in demonstrations. Well, the Constitution of South Africa makes it very clear in Section 17 that demonstrations and pickets, among other ways of communicating one's views, is permitted within the context of the South African Constitution. So certainly the arrest of Nhlanhla should not be seen with the context, within maybe the context of the state trying to muzzle him and prevent him from demonstrating and expressing his views and the views of the organization that he represents. Because if the police were to arrest him for that, surely that would be a revert to draconian apartheid legislation and ways of policing, and that would be inexcusable. So then if his arrest is not to prevent him from carrying out a demonstration, what could be a legal basis for an arrest of this kind? Now, it is very important for us to recap on exactly what are the events, or what are the events leading to the arrest of Nhlanhla Lux. On Sunday, just some 4 or 5 days before his arrest, while in the company, or rather leading the members of the Dudula movement in Dobsonville, Nhlanhla Lux and his companions entered the home or the premises owned by a certain man there in the neighborhood in Dobsonville, who was implicated, or rather who was suspected of selling drugs. The community reportedly told Nhlanhla Lux and the Dudula movement that this man in Dobsonville was involved in selling drugs to youngsters and to children. So in a kind of public wrath and anger, the Nhlanhla Lux led a group of people who supposedly entered, in fact allegedly entered the home or the house of that man in Dobsonville without a search warrant, ransacked the home, searched, and the owner of the premises reports or claims that his premises were broken into without a valid search warrant. You will recall that anybody who enters the property of another without a search warrant actually violates the privacy of the owner of the property and everybody who resides there. In fact, it is a criminal offense because you see the law has structures in place, the powers of arrest. Yes, we do hear time and again people talking about the powers of citizens to arrest, but the Criminal Procedure Act 51 of 1977, read together with the Constitution and other important legal documents, makes it very clear that arrest is carried out in clear and circumscribed circumstances under specified procedure. So if you take the example of the owner of the premises in Dobsonville, if the premises were entered without a valid search warrant given to Nhlanhla Lux and to the Dudula movement, then surely entry into his property was and would have been in violation of the law. Because you see, Section 22 of the Criminal Procedure Act outlines the circumstances in which premises may be entered and searched. Read together with Section 25 particularly, one finds that the requirement for any search is that the person carrying out the entry and the search of premises belonging to a person suspected maybe of committing a crime must be preceded by a valid search warrant. But the requirement for a search warrant gets dispensed with if it can be demonstrated that the person, the owner of the premises or the occupant of the premises being searched was about to, relocate or move away the material or the property used in the commission of a crime, or was about to destroy it, and there was some agency warranting that entry into premises without a warrant. So in this particular case, it is very misleading for journalists and everybody else to look for the explanation for Nhlanhla's arrest by looking at maybe the right to demonstrate and to picket and so on, because that is not the reason why why a case was opened against him. It's a case of housebreaking and theft. So if that be the case, then all answers, all focus must be on the definition of the crime of housebreaking and theft to establish whether the conduct complained of involving Nhlanhla Lux and the rest of his companions meets the definitional elements of a crime of housebreaking. Those who are being honest with themselves will admit that entry into premises of another person without a search warrant, particularly if one is not even a police officer and cannot even justify why an urgent search was necessary, such an entry and such a search is actually a commission of an offense. You see, the interesting thing, and what one would look at is that Operation Dudula has been operating outside the law, if one would say. Some people will find this very controversial, but look at it this way. If the law of South Africa were to allow a scenario where a group of people may just move around in the street and enter premises belonging, say, to a drug dealer, or premises suspected of maybe being occupied by an illegal immigrant, or they meet somebody in the street and they start asking people to identify themselves to prove whether they are legally in South Africa or not, or enter the business premises and start interrogating people, citizens doing that. Honestly, while some people might think it's a great idea because the narrative seems to be that they are targeting illegal immigrants, one question that one would always want to ask is, how do you identify an illegal immigrant by meeting him on the street or meeting her on the street? Without really openly admitting it, allowing such operations would, in law, result in a kind of a self-help, which is actually not acceptable in law, because if you read through the Criminal Procedure Act 51 of 1977, among other things, it outlines how prosecution, or rather of crime, must be carried out, rather starting from the process of suspicion of involvement in crime right through to issues such as search, entry into premises, searches of premises, seizure of property, or whatever items are suspected of being used in crime. That procedure is meant to bring law and order in society by appointing an institution such as the police to actually carry out those searches and those seizures within the confines of formal procedure. Because you'll notice that if everybody were to just jump around and run around without adhering to laid down procedure, that would result in a very chaotic society. And in fact, nobody would be safe in such a society. So, whilst it may be very inconvenient for Nhlanhla Lux and the rest of the people that are sympathizers to him, it is equally regrettable that they have not been sharing sound legal advice within among themselves as members of the Dudula movement. Because honestly, they ought to have known what would be deemed legal or illegal in terms of their actions and conduct. One wonders whether they don't have a legal team to advise them on what is legally permissible and what is not permissible. Because for sure, entry into premises belonging to another person without authorization to look for what you deem to be drugs or whatever illegal material with the intention to do so constitutes a common law crime in South Africa, for which a prosecution that Mr. Nhlanhla Lux is facing is actually permissible in law. So people should stop looking for the explanation for his arrest around issues of whether the law is trying to prevent him from demonstrating. Far from it. That's not the issue. The issue is housebreaking, which he must have avoided. And anybody who wants to carry out demonstrations and pickets must do so within the confines of the law. That is just what it is. I hope you find this very useful. Thank you very much.